Today's question is, what is the argument for the legalization of divorce? Well, there are many, but I'll try this one. Divorce is a necessary option in certain narrow circumstances, or at least it should be. Recklessly divorcing is as right as is recklessly driving. It happens, but it's still wrong. Before no-fault divorce became the law, one could not obtain a divorce without having a marital fault-based reason for seeking a divorce. Those marital faults were few and specific, though not necessarily the same in every jurisdiction. Here is a list of the most common marital faults that constitute a basis for divorce. In other words, they still have fault bases for divorce. For example, impotency of the respondent at the time of marriage, adultery committed by the respondent subsequent to marriage, willful desertion of the petitioner by the respondent for more than 1 year, willful neglect of the respondent to provide for the petitioner the common necessaries of life, habitual drunkenness of the respondent, conviction of the respondent for a felony, cruel treatment of the petitioner by the respondent to the extent of causing bodily injury or great mental distress to the petitioner, irreconcilable differences of marriage, incurable insanity, or when the husband and wife have lived separately under a decree of separate maintenance of any state for 3 consecutive years without cohabitation. Now, the list I just recited constitutes the fault-based grounds for divorce as articulated in Utah Code Section 30-1-1 sub 3. Other grounds in other jurisdictions include conviction of a crime that can result in imprisonment, usually for a year or longer, contracting a, quote, loathsome disease, close quote, usually a sexually transmitted disease, mental illness, substance abuse, infertility, homosexuality for heterosexual married couples when the homosexuality was concealed from the spouse before the marriage, failure or refusal to support the spouse financially, and, get this, quote, when either party has joined any religious sect or society which professes to believe the relation of husband and wife unlawful and has refused to cohabit with the other for 6 months together. This last one is a ground for divorce articulated in the New Hampshire Revised Statute, Section 458, sub 7, causes for divorce. Fault-based divorce ceased to be the only way to obtain a divorce when no-fault divorce was made law. While fault-based divorce is still available, no-fault divorce is an additional and much easier way to obtain a divorce. Some believe that no-fault divorce means that my spouse cannot file for divorce because I'm not at fault. In other words, no fault. Not so. In fact, no-fault divorce means almost the exact opposite. Under no-fault divorce laws, one can petition or complain for divorce without having to plead marital fault as the reason for seeking the divorce and without having to prove marital fault to obtain the divorce. When no-fault divorce was made law, it was believed that it would provide relief to spouses who were in miserable, dysfunctional marriages, but who did not have any of the fault-based reasons for seeking a divorce. In that respect, no-fault divorce succeeded. An unintended consequences of no-fault divorce, however, is that it made it too easy to obtain a divorce, resulting in more harm than good to many marriages. The destruction of a marriage and a family and all the attendant consequences, to be exact. Too many couples ended up, and still end up today, divorced when they could have and should have stayed married. They would have been happier and healthier, both physically and mentally, and wealthier had they worked on saving the marriage and family rather than breaking them up.